Hello, Norman. Good to see you. How are you doing?
Nice to see you, Russell. Very
Brilliant.
well, thank you. Yes.
Good. It's good to see you today, and to hear you talk a bit about the LLM in Canon Law from Cardiff. I, of course, graduated from that course in 2010, but I'm really
20.
interested to hear from you about how it all started.
Right. Well, I mean, well, obviously there is a very personal element in whatever I say when I talk about how it started. We go back, I suppose, to the 80s. I was doing a doctorate in medieval law, and I had to deal, of course, with the medieval canonists a bit. And one of my supervisors, Walter Ullman, he was, of course, in the 70s and 80s, the greatest historian of the medieval canon law. And anyway, I finished that, came back to Cardiff, carried on playing the organ at St. Edward's Church, Roath, which I've been doing incidentally for about 43 years, and wondered where all that canon law had gone. And in a conversation with a colleague in the law school at Cardiff, Thomas Watkin, who was then legal advisor to the governing body of the church in Wales, had a conversation with him, and on his desk there was a little, what looked like a white pamphlet with purple writing on it. And the pamphlet was the Ecclesiastical Law Journal. And I said, what is that? And he said, well, this society has just been set up. This was 1987, 88. And I said, well, goodness, now what has happened to ecclesiastical law? Because the universities don't teach it. You know, it died a death in the 16th century with the dissolution of the canon law faculties of Oxford and Cambridge, and no modern law school does it. So I said, I think I'm going to introduce a master's degree, part-time master's degree in canon law, so that we can develop a community of people who enthuse about, stare at the legal texts of, and think critically about church law. And so that was really the idea. That's where the idea came from, just me wondering where all this stuff had gone, then realizing, of course, that there was even a society that had just been established to devote itself to the study of and debate about ecclesiastical law. So that's where the idea, really, market forces, that's all it is, really. It's just responding to this event in history, that is the resurgence of interest in England, that is, not in Wales, in ecclesiastical law. So there we are. That's where the idea came from.
And how did the university, the law school, react to your idea when you brought it to them?
Well, quite frankly, and I know this is for public consumption, the law school thought I was quite mad, so I had to be circumspect about it. The law school thought I was quite mad, and I remember meetings in the law department, and there was opposition to it. And I remember one colleague saying, how on earth in Thatcher's Britain can we introduce at a thrusting modern law school the study of canon law? Anyway, we had a wonderful head of law school at the time, Edward Brown, and he was deeply supportive. That was the time when University College Cardiff was part of the wider University of Wales. Cardiff University has gone its own way since. So it then had to go through the law faculty of the University of Wales. And we were alerted, I was alerted to potential opposition from the old law school at Aberystwyth. But we weathered that storm as well. But the key thing really was to get the support of the Ecclesiastical Law Society. And Thomas Watkin and I went to the conference of the Ecclesiastical Law Society in Nottingham in 1989, and I had put together a paper which I was going to present to the education working group, then I think under John Masding and possibly Huey Jones, Archdeacon Huey Jones, and put it to them. They liked the idea. David MacLean, who had been chair of the House of Laity of the General Synod of the Church of England, professor of law at Sheffield, he put the resolution, put a proposal to the full meeting, the AGM of the Society, suggesting that they support the introduction of an LLM, a master's degree in canon law at Cardiff. And I was sitting up the back of the lecture theatre, Russell, with all those bobbing heads in front of me, 120 of them, and right down at the front in this world that was very remote from me, you know, the movers and the shakers in this great new society. And I sat there in the shadows of the back, and lo and behold, I couldn't see any heads anymore because all the hands went up. unanimously to support this little initiative of mine at Cardiff. And so it came to pass. The ELS supported it wonderfully and always has over the years. The law school eventually saw some sort of merit in it. And then in 1991, we instituted we had the first weekends, the first intake in 1991, September 91. We actually held the Ecclesiastical Law Society conference in Cardiff on authority and the courts of the church in April 1991, and then the first intake was September. And amongst the first intake, I mean, Oswald Clarke, extraordinary figure in the modern history of the Church of England, the Dean of Arches, Sir John Owen, leading the way. I mean, it was support, you see, from people like that was absolutely critical to the success or failure of this venture. So this was back in 1991. And of course, I must mention the chair of the Ecclesiastical Law Society, Mark Hill, who was almost a babe in arms as a member of the first intake. He was the youngest in the group. I can see him now in his red pullover. And he was, of course, he was a wonderful contributor to the discussions, the foil with the experience of John Owen, and then the critical insight of Mark. That sort of dynamic, not just between those two, but in the whole group. So we had waiting lists for years, actually. There was a 3-year waiting list for this. So that was how it was started in 1991 with the first intake.
Fantastic. And so it's part-time and it's residential, isn't it?
It's part-time and it's residential, yeah. And it has been from the beginning. I've got here, actually, strangely, a mask that my wife, Dr. Payne, who is advising on COVID every day, all day, she has made for me. I've just found it in my pocket. Anyway, on we shall move. Yes, it's residential. It's 2-year course. Well, actually, it's almost 3 years, because the first part, stage 1, is the taught part with 4 essays, 5,000 words each, on 4 distinct modules, more of which in a second possibly. And then part 2 is a 15,000 word dissertation. So you have 2 years worth of residential weekends in Cardiff at St. Padarn's College in the Latin quarter of the city at Llandaff by the cathedral. There are 4 modules, so 2 weekends per module. So it's residential. You turn up on a Friday night, and the old warden of St. Michael's College, as it used to be in the 90s, he always used to gather us together for a glass of sherry in the common room, and we've done that ever since. So the whole weekend is a mixture. It's an interplay of seminars, of workshops, of lectures, of sitting around the table, eating together, chatting in the common room. It's a deeply collegial experience. A lot of talking, a lot of laughing, and a lot of speculation about law. So yeah, it's a 2-year thing. You do the 8 residential weekends, 4 modules, and then the dissertation. And the seminars, we have guest speakers. The methodology is quite interesting as it has evolved over the decades. We look at law, we start with legal texts, obviously. You start with a canon or a measure of the General Synod or a rule in the Roman Catholic Code of Canon Law, and you just try and make sense of it. You describe its terms, understand the legal structure of the norms in question, whether it's about rights, duties, whether it's a principle, it's about a privilege, or whatever it may be. So you understand the structure of the text. Then we move on to try and explain the text. Now, this is where the door opens to a host of worlds, because we try and read the text theologically, or sociologically even, or philosophically, in the light of civil law. So we look at the text and explain it by reference to the intent of the lawmaker, by reference to the theology underlying the rule that is contained in the text, by reference to the purposes that it seeks to achieve, this rule in being made. We look at it in those sorts of ways. So explain its development, its purpose, its theology, its history maybe. And then we look at it, thirdly, another part of the method is to be critical, evaluative, and assess the norms that we read in the books. You know, and we use all sorts of criteria, simple criteria that all lawyers use. Is it clear? Are the norms consistent? We have a comparative element. How do they compare with other norms in other texts? How much do they cost to implement? Are they actually workable? Can you even enforce these things? Are they concise enough, or are they comatose? Are they just dead words on a piece of paper? So our function methodologically is to try and, as the legislator has been stimulated by the life of a theological idea to create a law, and then that law has a life of its own in practice in terms of shaping conduct, because law is simply norms of conduct, then our function is to reanimate these norms in a kind of scholarly way to explain why they exist, how they operate, and what their value, if any, is. And a lot of the time, of course, we have to operate in the world of assumptions. There's very little evidence and legal evidence about the meaning of words, about the purpose and the effect of words. So we have to speculate, and that is deeply important, of course. And then we draw on the experiences of the students, more of whom in a second. So that really is how it is taught through. You write essays on your modules, you write a dissertation, but above all, we argue, debate, laugh, cry about this entity, ecclesiastical law, in the seminars. That is where the community is built.
Absolutely. I mean, I found the community so important. I made great friends, just so many wonderful discussions late into the evening about the issues that have come up. And I really appreciated how much the course combines, as you say, the legal, the theological, the historical, ecumenical, all of these things coming together make for a really rich discussion. And and the fact you have those other students coming from all those different backgrounds.
Yeah.
To say something about the sort of students who come on the course?
Yeah, absolutely. I mean, the students come. We've never really done a study on why it is people do this. So, you know, it's been going on almost 30. It'll be 30 years next year, and the students really. It's part of the topics, I suppose. The topics originally, you see, the main focus was Church of England law, the law of the Church of England, the established Church of England. But then students come along from different experiences, from different backgrounds, religious backgrounds, professional backgrounds, and so they want the market requires that we change the topics. So originally it was Church of England law with a little bit of comparative law with Roman Catholic canon law, because the Roman Catholic Church, of course, has generation after generation of scholars who have studied the Catholic canon law. So originally the subjects we'd study were simply the conceptual foundations of canon law. What are the sources? What are the purposes? How is it related to theology, for example? Then a second part of this, the first module is the history of canon law, unbelievably ambitious, from the early church, the New Testament times, through the Apostolic Church, the huge medieval developments on canon law in the Western Church, through the Reformation to today. So that's history of canon law. Then we have a module on government and ministry. So we look at the constitution of churches, originally the Church of England. What are the institutions of government, from General Synod down to parochial church councils? What is the court system? Who are the legislators in the church? What are their powers? What are the relationships between institutions? What are the limits on the exercise of powers? So that's the government bit. And then ministry, of course, bishops, priests, deacons, lay officers, laity. What are their rights? What are their duties? How are they appointed? What qualifications do you have to satisfy to become a member of one of these classes of ecclesiastical person within the church? So that's the second module. Third module is on doctrine, liturgy, and rites. So what is the doctrine of the Church of England? Is it legally defined? Is the church competent to change it? Who creates the liturgical text? How are they supposed to be administered? Is there any system of discipline? And then rites from baptism to burial, through marriage and so on. The law applicable to all these things. And then the final module is on church property and church and state relations. So the students look at this stuff and they say, well, am I the slightest bit interested in that? Now, originally, Church of England people were interested in it. Now, for some strange reason, around 1990, well, I think I know the reason for it, but around 1999, 2000, people from around the Anglican Communion came to do the course. From the West Indies, a diocesan judge in the West Indies, from South Africa, from Canada, the USA, Australia, New Zealand, Ghana, Nigeria. And so you have to change the tack. You can't concentrate solely on the Church of England. And so we widen it to the legal systems of Anglican churches around the world. And we catch up by producing the literature that satisfies that market. So it's not just, you know, the students say, we want to study this. Okay, we study that. But you've got to then produce, say, literature. And the Ecclesiastical Law Journal has been superb in stimulating, encouraging, and accommodating this developing literature. So the students then, around 2000, Anglicans. Around 2010, we started having Methodists, and then Lutherans, and then Orthodox. We've currently got 2 Orthodox who work in the Ecumenical Patriarchate of Constantinople. So they're the sorts of students. The principle originally was half lawyers, half clergy. In Cardiff, you see, you have half and half, chips and rice with a curry. And so we said it's going to be half and half lawyers, half clergy, and that basically is how it has panned out over the years. And the lawyers, junior lawyers, diocesan registrars, chancellors maybe, and people, lawyers who then become chancellors and registrars. About 10 plus students, maybe 15, have become diocesan chancellors over the years. The clergy, from parish clergy to bishops, we've had about half a dozen bishops over the years. From the US, from Ireland, from Wales, from England. So they are the students. But the exciting thing is this ecumenical dimension. And we are now getting people from different Christian traditions to come together and use law imaginatively to see what they share and how they can work together and better understand each other. So that's been a major thing. So in terms of students and method, this ecumenical dimension has really changed it the last few years. We now look at not just the laws of the Church of England, comparing it with Roman Catholic, looking at the wider Anglican Communion and laws in the provincial churches. We now look at the laws of Methodist churches around the world, the Orthodox, Reformed, Presbyterian, Baptist, and so on. And that we feed into other initiatives that we're involved with through the Centre for Law and Religion at Cardiff Law School, which we set up in 1998. So we now have this community of students, we have this community of scholars, and we're all working in these different areas on those sorts of topics.
Absolutely. And the last part, I think, as you touched on, the last part of the course is the dissertation, and each student chooses their own area to focus on in the dissertation.
That's right. I mean, the dissertations. Usually, students turn up at this the first weekend, and we sit around the table and say, why are you doing it? Oh, I'm doing it because my work, I have this sort of aspect to my work in the church or for the church. And I thought it'd be quite interesting to develop my career, to develop my thinking about these things, to give me an opportunity to think in a disciplined way and write essays about these things I'm dealing with every day. If they work for the church commissioners, if they work for General Synod or the legal department, whatever it may be. And so the students come along thinking, oh yes, I want to do this. They say, I want to do a dissertation on X on the first weekend. And then, of course, through the exposure to all these subjects and all the variety of issues and matters that relate to them, they change their mind. And so by the end of the time, they've come up with a different dissertation. Now, the general thing is, with a dissertation, I encourage students to do something that they would publish. And I encourage them to do a study that is related to their work, that will keep them fired up for several months, and that in the end, they will think about publishing in a journal or even as a book. And over the years, we've had dissertations that have been published in the Ecclesiastical Law Journal, in other journals, and as books. So that's an important consideration. When we talk about the dissertations, again, whatever the topic is, there are all sorts of ways, having studied this course for 2 years, by which you can study the dissertation. So is it going to be a theological dissertation? where you try and squeeze out or understand the theological significance or features or purposes of particular legal rules in an area. Is it going to be an historical dissertation? Is it going to be a critical dissertation where you take a current body of law? For example, there's some dissertations the last couple of years and currently on the clergy discipline measure in the Church of England, which is obviously at the moment subject to quite a bit of public criticism, and there are moves to revisit the operation of the measure. So you can have critical dissertations that are effectively reforming dissertations, where a student takes a subject, looks at it critically, but doesn't get bogged down in the history of the wretched thing, because if you start looking at the history, you end up sort of 5-6 months later still looking at the history. So they look at the contemporary law and they look at it critically in accordance with their yardsticks or their criteria of criticism that they're going to apply to it, and then they will suggest reforms. And sometimes they end up suggesting a draft bill in Parliament or a draft canon for consideration by General Synod. We have an Irish student, Stephen Farrell, some years ago in Dublin, and he did his dissertation on the election of bishops in the Church of Ireland. And then he fed that into the reforming process in the Church of Ireland for readjusting the laws on the election of bishops. So that's dissertations. They can be on any topic, usually related to your area of work, because these people are part-time students, and with an eye to publication, and it can be a theological, historical, or whatever. But increasingly, they are becoming more ecumenical, comparative in their scope, and using them in the practical world is an important thing, I think. I mean, some dissertations are done for pleasure on wonderful subjects, interesting for their own sake. But for me, the better dissertations are the ones that look at some reality, some issue, and address that issue critically using law imaginatively.
Oh, wonderful. Oh, thank you. Thank you, Norman. So how many people since 1991, do you have a rough estimate how many?
I think approaching 250, I'd imagine. I mean, the deal with the university back in 1991 was you cannot take more than 10 students a year. Mm-hmm. Okay. Sometimes it was up. About 10-15 years ago, the numbers went down. The fees, issues about fees and so on. It's not an inexpensive degree. And they have fluctuated over the years. But we have a group now of 18 students doing it. But I'd imagine over the years, 200 students. And what we have done until a couple of years back is have a reunion each year of the students. We meet at tea time, we have a seminar and then a dinner together, and then some worship usually in a college chapel. And it'd be good to revivify that little tradition. That's sort of died a bit of a death the last few years. But there are other networks associated with the Centre for Law and Religion through which the students can continue their interest. The Colloquium of Anglican and Roman Catholic Canon Lawyers, of course, of which you are a member, along with other LLM students, former students, the Interfaith Legal Advisors Network, getting Muslim, Buddhist, Jewish, Christian lawyers together, the Law and Religion Scholars Network, which has about 300 members worldwide these days. So there are other opportunities to continue an interest. And of course, some students who have done the LLM want to do a doctorate in it. They want to take a particular subject and explore it more fully. And we've had several of those over the last several years as well.
No, that's brilliant, Norman. Thank you. Thank you. And you just touch on those other networks. Maybe sometime in the future, you come back and do another interview. We could talk about the Anglican Roman Catholic or the Interfaith.
It'd be an absolute treat, Russell. It'd be lovely. I would love to do that. Thank you very much. Yeah,
absolutely. Is there anything else you wanted to say about the LLM today?
No, I think that's about it, really. Gosh.
Yeah, no, that's covered a huge amount. It's so exciting. I mean, I just want to say it really is such a fulfilling and interesting course to do. You know, for me as a parish priest, and finding out a little bit about the world of ecclesiastical law and getting involved. It's been really, really terrific. Beginning of a journey for me, which has been wonderful. And
well, that is just marvelous to hear. It's really wonderful to hear. Thank you, Russell, ever so much.
Great. Well, thanks for talking today.
Okay.
And
you take care.
Take care.
Ta-ra.